Got that done. All right. Well, I won't spend much time, but Professor Esbeck is a longtime acquaintance of mine and was now retired from the University of Missouri as a law professor, but his specialty, in addition to his heart for the local church and for his family, has been thinking about the issues of constitutional law and religious freedom issues. Just last week, I noticed, Professor, that you were invited to be a part of the National Association of Evangelicals and a dialogue that you had there because of your work for several years with the Christian Legal Society and the continued work that you've had. So you have a long list of accolades, including work that you've done with various critical cases that have gone and briefs that you've filed, and are now able to give yourself to that in some pretty significant ways. And on a local level as well, has been helpful to us as church planters back even 30 years ago to ensure some equal access issues and to be able to get access to public facilities like the schools, et cetera. So we've gotten to walk together in those kinds of ways. So grateful for that as well. And any reflections on the NAE interview? That was kind of fun and exciting, I assume.
Yeah, it was good. One thought is we have NAE has a new president, Walter Kim. Pastor Kim was pastor of the church just off the Boston Commons. Park Street Church, sort of a famous church, and then had just gone down to Charlottesville, Virginia, to Redeemer Presbyterian, where he continues to be pastor and is the new president of National Association of Evangelicals. So it was good to be with him and get to know him a little bit better. He's Korean American. His parents were born in Korea. He was born in the U.S. Good guy.
Well, I'm excited for the fresh blood in that organization. And also, I like the kind of work that they're doing. But I was really proud of you to see your name pop up on that national email and for them to promote it. I didn't watch that or listen to it in order to be fresh and with you today. So I want to begin by asking you, Carl, if you would just describe your sort of impressions at a 50,000-foot view of religious freedom in this current climate. And are you encouraged? Are you discouraged? Are there any surprises, even with the newest Justice Brett Kavanaugh and the ways in which he's ruling? Yeah, so it's just some of your general reflections in this climate.
Well, short term, in America, there's just a little bit of an uptick in the protection of religious liberty. But over a little bit longer stretch, say 20 or 30 years out, there's some real cultural challenges, and that culture in a democratic society soon gets represented in the laws of the majority. So we're on I think long term, say 20, 30 years out, we're on a gentle decline downward, and we'll be struggling more and more for religious liberty in America. And it sounds sort of super patriotic, but it's true that America is sort of the high watermark for the world in terms of religious liberty. And what happens here, whether it's up or down, affects the rest of the world. Right now, religious liberty is on the decline worldwide. More and more religious persecution. And we monitor that through various State Department agencies and independent agencies. But our current Secretary of State is keenly interested in international religious liberty, which is refreshing. And one of the reasons I say that we have a momentary uptick. But But long term, a slow decline, at least as far out as I can see, 20 or 30 years. And so it calls on good men and women who follow Christ to stand up and to civilly speak and to declare our need for religious liberty, not just for Christians, but for all others, because when all others are protected, then the gospel wrestles on an even playing field, and I'm quite confident that the gospel will win out on an even playing field.
Well said. Any surprises with the newest justice?
Well, there's really two, of course. Gorsuch is still relatively new, and then Kavanaugh. Let me start with Kavanaugh, since that's who you had in mind. He consistently voted for religious liberty. So that's positive and was expected and hoped for. He does seem, he's often writing separately, even if he joins the majority opinion or joins a dissent of another justice, he'll write separately, and his words are very temperate. And my own surmise, it's just an educated guess as to why he's doing that, is, as you know, he had a very difficult confirmation hearing. And I think he's just trying to say, hey, you know, I'm a good guy. I'm a moderate conservative, but I'm a good guy. I can be empathetic to others with whom I respectfully disagree. So I would say that that's slightly defensive on his part, but anyway, that's my reading on him. His voting pattern is good on religious liberty.
Yep.
Gorsuch, of course, the first of the four cases I'm going to talk about, the Bostick case, he wrote that. And of the four cases, it's the loss of religious liberty. The four cases are 1 loss, 3 wins. And he authored the big loss in a 6-3 case. He was joined there by, of course, the 4 liberals and then also the Chief Justice Roberts. And so that was a big disappointment. On the other hand, he was a strong proponent of religious liberty when he wrote separately in the 3 cases where religious liberty came out on top. And if anything, he joined with a couple of concurring opinions that had a somewhat extreme view of pro-religious liberty. So he may have been trying to signal that to reassure the religious community. He himself is an Anglican, which is different than Episcopal. I assume many people here on this Zoom are aware of the difference here in America. So he's an Anglican and so a believer. And I think he was trying to say, you're unhappy with me about that Bostick opinion, but I just want to reassure you in these other religious liberty cases that I am strongly for religious liberty, which I do think is the case.
Very good. All right, well, let's launch on the first one, and I'll ask you, as I'm sure you're aware, we want to finish about 1:15. So that leaves us about 8 to 10 minutes for you on each case. And then if you'll give a brief pause after you cover the first one, let me interact, and maybe I'll ask for a question or two if it's pressing on the part of the rest. And so we'll work our way through all 4 of these. 1 win, 3 losses. And if you'll give them each a name, which I'm sure you will, that way in our question, we'll be able to specify which ruling you're talking about.
You bet. So I'm going to talk about these 4 cases in the order in which they came down. And as it happens, the first one is the one that we lost, and then followed by the 3 cases that religious liberty won. So the first case is Bostic versus Clayton County, Georgia. It's pronounced Bostic, but phonetically it's Bostock. And 6-3 case, majority opinion, as I've said, authored by Justice Gorsuch. And as so often happens, this is really 3 different cases from different parts of the country, which the Supreme Court then consolidates them, and they're argued together in a 1-hour argument and decided all together. So 2 of the cases involved charges of employment discrimination on the basis of sexual orientation. And the 3rd case was a charge of employment discrimination based upon transgender status. So that's why you have 2 homosexual cases, 1 transgender case. But they were consolidated because it's essentially the same legal question. Did the Civil Rights Act of 1964, Title VII of which prohibits employment discrimination on various bases, religion, race, color, sex, national origin, did the prohibition of sex discrimination also include discrimination on the basis of sexual orientation and gender identity? Of course, gender identity is their euphemism for transgenderism. And by 6-3, the court said yes. So as a result we've got this 55-year-old Civil Rights Act, which heretofore did prohibit sex discrimination in employment, now also prohibits sexual orientation discrimination and gender identity discrimination. So major dissent by Justice Alito, joined by Thomas and Kavanaugh. So Justice Gorsuch says that he is an originalist. Original intent is what he's looking for, and he looks almost exclusively at the text. And so he looked at the text of the Civil Rights Act, and it said it was discrimination if it was an adverse employment decision because of sex. And all parties agreed that back in 1964, when Congress used the word sex, they meant biological male and biological female. But the case law had developed interpreting Title VII that because of sex encompasses actions that would not have been taken but for the sex of the employee. And the sex of the employee doesn't have to be the sole reason for the adverse employment decision, but just a reason, or at least a substantial reason. So there may be multiple causes for an adverse employment decision, but if sex was one of the major reasons, then it's unlawful sex discrimination, or it's discrimination because of sex. So let me describe to you what Justice Gorsuch did with a couple of illustrations, simple little illustrations. So let's say we're at a place of employment. We have 3 workers. They're all good workers. They've worked for me 5-6 years. And they're Amy, Bill, and Chuck. And at my place of work, I have various work rules. And one rule, longstanding rule, has been no fraternization. So employees, co-employees are not to date, because romantic relationships, which go sometimes positive and sometimes negative, are disruptive to the place of work. So no dating, no fraternization. So a new workday begins, and it begins with Amy declares her love for Chuck. And a couple hours later, partly in response to what Amy did, Bill declares his love for Chuck. And the next day, the HR director calls in Bill and fires Bill. Nothing happens to Amy. So if you look at this, you know, if Bill had been a woman like Amy, Bill wouldn't have got fired because Amy didn't get fired. So it looks like this adverse employment decision was, at least in part, because of sex. And that's what the majority opinion here said. Now, of course, we know that the reason Bill was fired was because Bill, declaring his love for Chuck, thereby announced that he was gay. All right, here's another simple illustration. We have two long-term employees, both excellent annual performance reports. They've been working for me for 10 years, Linda and Sam. And so as the boss, I decide one Friday night, I'm going to hold a Christmas party at a local restaurant. A nice meal and celebration around Christmas season. And employees are invited, and if they're married, they can bring their spouse. And if they're not married, they can bring their significant other. So Sam shows up, and he has a girlfriend, and he introduces her around as his girlfriend. Linda shows up and also has a girlfriend, and Linda introduces her girlfriend around as her girlfriend. On Monday morning, the HR director calls Linda in and fires her. Nothing is said about Sam. So again, if you look at this, if Linda had been a male like Sam, she wouldn't have been fired. But Linda being a female, she was fired, and that adverse employment decision then was apparently because of sex. And that's how the court is interpreting this 1964 Civil Rights Act. Now, of course, we step back and we know, we've known Linda was a woman for 10 years. The new information that we acquired for the first time at the Christmas party is that Linda also was a lesbian. So we know the truth. Linda was dismissed based on sexual orientation and not because of her sex. But nonetheless, Gorsuch interpreted, using textualism, he said, but what he did was a bastardized form of textualism called literalism. That's not what we think of as an interpretive principle in the law. When we think of textualism, we think of giving words their ordinary meaning, not their literal meaning. And unfortunately, Gorsuch went off the rails, and he was joined here by Justice Roberts and gave it a literal and not an ordinary meaning. So that's the rationale of the case. This has profound consequences, negative for religious liberty, or if you're a seriously religious employer. And in particular for religious organizations, because the Civil Rights Act of 1964, Title VII, is applicable to religious organizations like any secular organization, as long as you have 15 or more employees. So the negative consequences, there are defenses to this. Now, the three employers here in the Bostock case were all secular. So they, of course, had no religious defenses. But if you had been a religious organization, of course, religious organizations are now going to be sued under this new interpretation and sued for sexual orientation or gender identity discrimination. You've got three defenses. One is Title VII itself has a special defense just for religious employers. So a religious employer can discriminate on any basis if the employer is doing so because of its religious beliefs or practices. So if the adverse employment decision had something to do with your religion or your biblical interpretation of homosexuality or transgender, sex change operations and so on, then you would have a defense under the statute itself. Second, there's something called a ministerial exception. So if the adverse employment decision went to an employee who is also a minister in terms of their job description, then the Civil Rights Act doesn't apply at all. And we're going to talk about what the ministerial exception is in the fourth case that we're going to get to this afternoon, Our Lady of Guadalupe. And then under the Religious Freedom Restoration Act, which is congressional statute passed in 1993 under the Clinton administration, if a federal law, and of course the Civil Rights Act is a federal law, if it imposes a substantial burden on you, you have a RFRA defense. So it's not that religious organizations don't have defenses. The question is, will those defenses be successful? And like all defenses, sometimes they're successful, sometimes they're not. So this Bostick ruling opens up religious organizations and religious employers, even for-profit religious employers, to lawsuits that now they're going to have to rely on defenses which may or may not be successful. That's not all. This interpretation by the court of what sex discrimination is, that was for Title VII, but there's all kinds of federal laws that prohibit sex discrimination, like Title IX, for example. Of course, I'm on campus and Title IX is everywhere. I have to once a year as a faculty member, retired or not, doesn't make any difference. I have to take a 3-hour seminar and pass an exam on Title IX, of course, which is about sex discrimination at institutions of education. So now, presumably, that the bar on sex discrimination under Title IX is also going to extend to sexual orientation and gender identity. So that's going to be a major expansion. Also, the Fair Housing Act of 1968 prohibits discrimination in housing and the like, property transfers on the basis of sex, along with race and other prohibited bases. The Equal Pay Act of 1963 is discrimination on the basis of race. And we're going to have affirmative action. As you know, we have affirmative action for women. And now, presumably, we're going to have affirmative action for gays and lesbians and for transgenders. And that's going to be very interesting. The Bostick opinion, because it's judge-made law, it's not statutory law, doesn't define gender identity. And there's all kinds of definitions of gender identity. And for example, there are people who claim to be neither male nor female, nor transitioning from one to the other, but they're something else other than male and female. They're fluid gender, or I'm constantly changing gender, depending upon my physiology and how I'm feeling. And so there's going to be all kinds of litigation to try and figure out what is and what is not gender identity. And then there's not just discrimination in employment in fact, but there's discrimination of another kind. For example, harassment. We're all familiar with the term sexual harassment. And those aren't adverse employment decisions. You're not fired, or you're not demoted, or you didn't fail to get a promotion or pay raise, but you're harassed because of your sex. So now, presumably, we're going to have harassment on the basis of being gay, lesbian, transgender. Or hostile environment is another form of discrimination. Even though there's no adverse employment decision, hostile environment, of course, suggests that it makes going and being at work unbearable because of a trait like race, national origin, sex, or now being lesbian, gay, transgender, and so on. So there's going to be all kinds of spillover, and it's going to take 2 or 3 years for all of that to evolve. And then a very strong dissent by Justice Alito. If there was the #1 pro-religious liberty justice, it's Justice Alito, hands down. Nobody else is even close. And he pointed out, this is going to create all kinds of problems. For example, female sports. And a male transgenders to a female and then competes as a female in sporting activities. I'm sure you've read about this, and they're full of testosterone, much more than their female contestants. And so they simply do better at track and field and basketball and volleyball and so on. And so they have an unfair advantage because of their testosterone and other hormonal physiology with females who have always been females. And that's seemingly unfair in sports competition, high school, middle school, undergraduate, college, and so on. What about the military? We, of course, have long had females in the military, but and homosexuals and transgenders in the I guess right now we don't have transgenders in the military. We did under the prior administration, but all that has to be worked out. What about housing? Housing in the military? How about housing at a state university, where in our dormitories, at the request of students, we have female and male dormitories at their request, for reasons of privacy and just general comfort. So how's that going to be resolved? How about healthcare? A number of religious organizations operate hospitals and clinics and other healthcare units, and for example, Catholics object, and presumably biblical Protestants object to sex change operations, application of hormonal therapy for somebody transgendering, because their basic religious beliefs are against transgendering. So is a Catholic hospital going to be forced to give sex change operations and hormonal therapy and so on, all against their Catholic beliefs? Privacy in the locker room. Some people sort of roll their eyes when we start talking about transgenders and bathrooms and locker rooms at the middle schools and high schools. But presumably there are still females of that age group who are modest about their body, actually quite a lot of them. And so they're discomforted at having a male who's transgendered into a female in their locker room and in their bathroom and so on. So how's that going to work out? And then there's free speech. As you know, large employers have, they require their employees to take and pass sensitivity training workshops so that you're inclusive and you're non-bigoted and you're fully woke. And so that you don't say things at the workplace which would be treated as racist or sexist. And so now that too is going to spill over into homosexuality and transgenderism. And so what's a devoted Christian who has beliefs about sexuality, its appropriate use and unnatural use? How are you to just shut up at the workplace, muzzle yourself, self-censor yourself, or can you, in an appropriate way, over lunch, express your understanding of what Scripture teaches concerning these questions? Prisons, of course, we normally segregate between men and women. So this ruling, just creates all kinds of interesting questions. People will be asking to change the designation of sex on their driver's license, on their birth certificates, on their passport, and as they say, yada yada yada. So, and the court itself, because while it's a court decision, it has all the look of a legislative body's product, social engineering. So the court itself, to the extent that it is to be a non-political or above politics, and to the extent that we revere the aphorism that we're a nation of laws and not men, of course, this kind of decision to read into an act of 1964 things that clearly were not there, breeds cynicism among Americans about law and its institutions. So Rod, back to you for questions on that. Bostic.
Yeah. Tell me about why I heard you say that Hobby Lobby is protected, but the Catholic hospital could be at risk. Am I missing something?
Well, Hobby Lobby was protected under RFRA, and we're going to get to that in a case that's coming up called Little Sisters of the Poor. But that's a statutory protection, and that was one of the three defenses that I mentioned. It was the third of the three, RFRA.
Right, okay.
And that's only a defense against federal law, though, not state and local anti-discrimination laws,
So
many of which...
Why is the Catholic hospital at risk?
Well, because they receive funding, federal financial assistance, under the Affordable Care Act. And the Affordable Care Act prohibits sex discrimination against patients. And now is sex discrimination in the Affordable Care Act to be read, oh, that's not just sex, male, female, double X or an XY chromosomes, but also sexual orientation and transgender.
Okay.
So
maybe
it's under
maybe
the Affordable Care Act.
Maybe the difference with Hobby Lobby will become more clear down the road. I'm still struggling with that. For the sake of time, let's go to the next one.
All right.
I am going to step away, but I'm not going anywhere. I'm still listening in. I'm going to take a quick break.
All right. So the next one is, the caption is Espinoza versus Montana. And it's a 5-4 ruling, victory for religious liberty under the Free Exercise Clause. And it's authored by the Chief Justice. And the particular issue has to do with whether the Free Exercise Clause of the First Amendment prohibits a state from singling out religion for adverse treatment. So the particular underlying facts is the Montana legislature adopted a modest school choice bill. What the legislature did, and 6 or 7 other states have done this as well, they passed a law that allowed taxpayers, income tax payers in the state, to donate money to a private trust fund, and the trust fund existed for the sole purpose of giving out scholarships to K through 12 students attending private schools. As you know, private school tuition is quite high. $8,000, $9,000, $10,000 isn't unusual over in St. Louis per year, per student, even for a grade school student. So it's pretty expensive for most parents and out of reach, economically out of reach for most parents. So Montana and other states have adopted this process, and if a taxpayer gives money to this trust fund, which gives out scholarships, you get a tax credit off your state income tax. So it's an indirect way of funding through a tax credit private schooling. Montana has a Blaine Amendment. So does Missouri. About just a little over 30 states have Blaine Amendments. And Blaine Amendments, which were adopted in the 19th century, prohibit any government money, directly or indirectly, from going to a church or other religious organization. So long story short, the courts in Montana said, well, this law violates our Blaine Amendment, our state constitutional Blaine Amendment, when the scholarships go to a student enrolled in a K through 12 religious school. And that, of course, is a straightforward, ordinary interpretation of the Blaine Amendment. The question is the Blaine Amendment, as applied there, promoting intentional discrimination on the basis of religion? And if so, which it is, the answer is yes. And if so, does that violate the Free Exercise Clause? Even though the reason for the Blaine Amendment is to promote separation of church and state. So by 5-4, the Supreme Court said, yes, the Free Exercise Clause is violated because of the intentional discrimination by Montana against religious schools. Because if a student has a scholarship and attends a private non-sectarian school, that's fine. But if they attend a private religious school, it's not fine. So it's intentional discrimination, and the court said, even though Montana's reason was to promote their version of separation of church and state, nonetheless, this is odious discrimination against religion. And this has real practical implications. Rod, the last time we did this, we touched upon very briefly the issue of the day a couple months back was the PPP. And the PPP stands for the Paycheck Protection Program. And a number of churches and other religious ministries were applying for and getting forgivable loans under the PPP. Well, if this case hadn't come out the way it did, all that money going out under the PPP would have been unlawful. But because of the result here, it was constitutional. And indeed, the PPP program could not give out forgivable loans, but discriminate only against religious groups. So this, this kind of comes under the heading, what life is there to strict separationism? And the answer is there's almost no life at all. That's really been true the entire 21st century. Only misguided radio evangelists still think that the separation of church and state still exists, at least in the courts, and it's been gone from federal law for over 20 years. And this case is certainly a demonstration of this. Now, of course, there are 4 liberal dissenters here are beating the drum of separation of church and state and Jeffersonian walls of separation and so on and so on. But none of that has been the law for some time. So this throws it wide open to school choice programs, for example, and Christians who operate private Christian schools, or all Christian schools are private, I guess. So Christian schools welcome this because it lifts the Blaine Amendment from blocking school choice legislation in Missouri and a number of other states. Now, that doesn't mean that school choice legislation is going to pass. It still, takes a majority vote in the 2 houses of the legislature and the governor's signature as opposed to his veto. But if you're going to defeat school choice, you just have to defeat it by saying we don't want it. we don't want it for other reasons, but you no longer can cite your state constitution Blaine Amendment, because the Blaine Amendment is no longer going to be relied upon as a way of preventing equal treatment of religious organizations. And of course, this is not just K through 12 education, but like here in Missouri, if you're generally aware of Bright Flight scholarships, which are merit scholarships for high school graduates, Missouri, until this decision, didn't let, if you were a student awarded a Bright Flight scholarship, you could not go to a Christian school and use your Bright Flight scholarship to pursue a ministry degree, you know, to be a pastor or a youth pastor or a worker in a campus ministry or things of that sort. And also social services. You know, it's been around since just before the turn of the century, and federal law, charitable choice, has said that there would be, at the federal level anyway, all charities had equal competition for social service grants and other social service funding. Government could not discriminate against a social service provider simply because of their religious character. And that's been the federal law under the rubric of charitable choice, which was John Ashcroft when he was senator. But now that's going to be state and local law as well. So it does free things up in terms of the ability for religious social service ministries, as well as schools and colleges, to operate with funding. So Christian parents that want to enroll their kids in a religious school or send their kid off to a denominational related school will be able to pursue equal funding in that regard. So Rod, good time to go back to you on Espinoza.
You mentioned the PPP, and the last time that we visited, you said that you and other attorneys were working to get the strings attached that would be problematic. So just quickly, I was curious if any progress had been made on that.
Yeah, to get the strings unattached.
Better said.
We're all familiar with the euphemism about, you know, the government doles out money, but then they attach strings.
Yeah, and so we were concerned that if you didn't get it paid off in a timely manner, that there were going to be strings attached.
Yeah,
mm-hmm.
Yeah, and the short answer is yes. We did get the administration to lift all strings but one, and that was, it's called the Rehabilitation Act of 1973, which prohibits discrimination in employment and the dispensation of services on the basis of handicap. So that's still there. So if your church gets a PPP, or if your campus ministry gets a PPP, or your charitable endeavor like Love Inc. Gets a PPP, you cannot discriminate on the basis of disability in employment and those you serve. Now, of course, many of those organizations would hasten to add, well, they've already made a powerful effort not to discriminate on the basis of disability, because they want to make everyone welcome to their ministry, and they want to hire the best person, notwithstanding disability, if that disability can be accommodated. But as usual in the law, things are not always that simple. And let me just give you one example. This is an old example, 25 years ago now, but there was a Christian ministry in New York City, didn't have a lot of money, and they were operating on the second floor of an old building. And they did want to serve the disabled as well as the fully able. but if you were confined to a wheelchair, they had to pick you up and carry you up the stairs and then carry your chair up. And of course, that's viewed by the disabled community as discrimination because you don't have an elevator. So New York City, who was funding this group, said, well, you got to put in an elevator. And an elevator at the time, I don't know what it would be today, would be $650,000. The total budget, the total annual budget for this Christian ministry was about $225,000. So needless to say, they could not put in an elevator, and therefore they lost their funding. So, sometimes crazy things happen, and so strings do matter.
Yeah.
So hopefully anybody out there who got a PPP has elevators and lifts and ramps and wide doors and are already fully accommodating the people you serve as well as your employees. So
very good. Well, thank you for your work, at least to get the other strings unattached. For the sake, again, of completing all four, I'm going to move now to case 3.
All right. This is the case I like best. And it's of the 4, it's the biggest victory. For case name, it's Our Lady of Guadalupe. It's actually 2 cases. Again, they consolidated them. Both of them involve Catholic K through 12 schools, and these Catholic schools in California, as to one of the teachers, they dismissed her for poor performance. They didn't fire her, but she had annual contracts, which is typical for K through 12 schools. You have annual contracts with your teacher, and they chose not to renew her contract after 3 or 4 years of renewals. They decided not to renew it again for poor performance, and she sued for age discrimination. And in the second school, a teacher again was removed for poor performance and excessive absenteeism, or at least that was the reason given by Catholic school authorities. But the teacher sued for disability discrimination. So the question arose, and they sued under Title VII. And the reason given by the schools for the adverse employment decisions was not a religious reason. So the statutory religious exemption in Title VII didn't apply. If they had dismissed the teacher or didn't renew her contract because, she had come out of the closet and declared herself a lesbian, and that's not consistent with Catholic theology, well, then that would be a religious basis for not renewing the contract. And the defense would be available. But here, it was a non-religious reason for not renewing the contract. So the schools relied on a First Amendment defense called the ministerial exception. So it doesn't exist in the statute at all. It exists in the case law, and it's very narrow because it applies only if the job position involved is a minister. So, pastors and priests and imams and rabbis are ministers, of course, but the case law has never required that you have a theological degree or that you be ordained in order to be a minister, and thus this exception applies to you. They understood that, a number of religious traditions don't have formal training for their pastors, like the Mormon Church has no formal training, like seminaries. And nonetheless, you can be a cleric in the Mormon Church. So, so to be a minister didn't mean that you had to be a cleric in the narrow sense, but nonetheless, you had to be a minister. So, for example, if you were a large church and you had a position called the minister of music, yet the individual holding that position did not have an MDiv or other religious training in the formal sense, but rather they had a music degree, typically a master's of music. Well, the court reasoned that, yes, but religion is integral to the worship service, and the worship service is certainly a religious function, an explicitly religious function. So we're going to treat the minister of music as a minister for purposes of this exception. Because if the exception applies, then the person can't sue. They can't sue for any reason. Sex discrimination, age discrimination, disability discrimination. They can't even sue for racial discrimination because it's a First Amendment exemption. And it's a very powerful exemption because it's largely rooted in the Establishment Clause. And so if it applies, that's the end of the case. It's not even like a typical religious liberty rights case where if the right applies, still the state can overcome it for compelling reasons. The ministerial exemption is absolute. If it applies, the case is over. We don't care why the person was dismissed or otherwise given an adverse employment decision. Maybe they were demoted, maybe their pay was docked, maybe they were put on probation for 6 months without pay. Whatever the adverse employment decision is, they simply cannot sue. And this goes all the way back, this goes back 2 millennia to what became a tradition in the Western civilization. And that is, to us, it comes under the rubric of 2 kingdoms or 2 swords or 2 cities. Or it goes back to render unto Caesar the things that are Caesar's and to God the things that are God. There is a differentiation which is healthy, a separation which is healthy between the institutional church and the government. And if you look for it, it's why the Apostle Paul, for example, can treat the state as having the sword. The church doesn't have the sword, and so on. There's a differentiation there rooted in Christian teaching, which folded its way into Western civilization over 2,000 years, and then moved across the North Atlantic into the British colonies to become the American states, and it's in our jurisprudence here. So it's a very powerful but very narrow First Amendment immunity. And here the court, technically by a vote of 7-2, said that parochial school teachers were ministers, which was a very generous interpretation of who is a minister. And heretofore, there was a strong case in California who was resisting this outcome. State of California, they said, well, you have to be a leader in your organization. Pastors are leaders. If you had a school, they were willing to stipulate that the school principal was a minister for purposes of the ministerial exception. But of course, teachers are not leaders in the normal sense of that term. To be sure, what they do is the frontline teaching interface with students. So what they do is important, but they're not leaders. So, so this was a very generous interpretation, and it got 2 liberal votes, Kagan and Breyer, as well as the 5 conservatives. So it's a very, very delightful outcome, and I expected a more mixed outcome. Quite honestly, and this case, in my view, could have easily been lost. They could have easily come down and said, well, this long tradition in Western civilization was to protect leaders from government interference, but not the rank and file. And we deem teachers rank and file. So now, who is a minister for purposes of, so for example, if you think of church, think of a large church that has 20 staff. You know, there's a church administrator, and there's probably somebody, a bookkeeper, and there's somebody who does personnel, and you know, there's people that do children's ministry, and there's people that do college ministry, and there's people that do middle school, and of course there's a senior pastor or a couple of co-pastors. So, and then you also have the grounds crew and the janitorial and just the run-of-the-mill administrators, secretarial, and so on. So who among those are ministers? And what the court said was, you don't have to be a leader, though leaders are ministers. But these teachers did explicitly religious functions. Every week, twice a week, in the classroom, they taught Catholic theology. Classrooms once a week. They didn't have to participate in mass. Protestants might say going to chapel. But they had to accompany their students and sit through the chapel and so on for reasons of, you know, discipline. And they were expected to counsel one-on-one troubled students. Maybe they were a discipline problem, maybe they were troubled because there were troubles at home, whatever, and be able to intelligently refer to a counselor if there were spiritual problems as well as other kinds of problems and so on. So, so the teachers did some religious functions. The schools did not require that the teachers be Catholic. And still, the court ruled 7-2 they were ministers. Now, think about that. I mean, California argued, how can you be a minister in a Catholic school if you don't even have to be Catholic? And still the court said, these are ministers, it's a legal term of art. And so, oh, and you don't need formal theological training, though that would be helpful if you were saying they were a minister. And you don't need to have the title of minister, though again, that would be helpful as we try to determine who are ministers. So who else might be a minister is going to have to be worked out. But this is a very generous protection from employment discrimination law of religious organizations, not just churches, but of religious organizations. So it would include your campus ministry, like InterVarsity, for example, or the Navigators. And it would include an organization like Love Inc., for example, social service Christian organization, or Coyote Hill. So back to you, Rod.
Carl, let's make the application to Christian higher ed. So if I go on faculty with a Wheaton College, for instance, and I sign a contract with them, then there seems to me, because it's a religious organization or a religious educational organization, then my contract, it seems, is in some sense null and void in terms of tenure, et cetera. Is that an implication or an application that I'm making correctly? Because of this gave power to the dismissal on the basis where I could not claim, my contract.
Yeah, sure. And the short answer is yes. Because you chose Wheaton College, and you and I know, as does our the rest of our group here, they're a thickly Christian evangelical campus. The harder question, and the ministerial exemption wouldn't apply to, say, Columbia College, which is historically Christian, but is no longer Christian. The tougher case would be, what do you do with a Central Methodist over at Fayette, which is kind of betwixt and between. Or what do you do with at Westminster College over at Fulton, which again is historically Presbyterian. And of course, there is a church on campus, and they do have a chaplain who's a Presbyterian chaplain. But I'm led to believe is largely non-Christian now. So what about their faculty? And I'm sort of inclined to say, just to be brief, that their faculty would not be ministers, whereas Wheaton College or Taylor University or Bethel College or coming here back to Missouri, what is it, Southwest Baptist down at Bolivar, that's their faculty.
It is curious because
it
is curious because it does make these educational institutions now sort of thoroughly Christian church organizations as opposed to playing in the educational field. So I don't know, I'm not making judgments per se about that, but this seems to be a pretty significant transition that direction, as opposed to, you know, the idea that I have tenure and freedom of participation if you go against the doctrines of that denomination, et cetera. Seems like the implications of this are pretty deep for them.
Yeah, although if you're familiar with the CCCU, which is Council of Christian Colleges and Universities,
yeah,
they welcome this decision.
How
now,
so?
Of course,
I mean, I don't see the faculty.
They want the religious liberty.
Okay, well, I don't see
the institutions want the religious liberty.
Yeah, I would think though that the Christian faculty themselves, in terms of, you know, depending on what environment they're in, they would find themselves saying, you have stepped on our academic liberty and freedom to be able to think freely or to speak more broadly, because oftentimes, you know, I don't have to tell you guys that those who are the presidents and the leaders and raising the funds from what, you know, one particular group don't want their faculty to have the kind of more broad interpretations and applications. So
yeah,
very curious.
Yeah, and of course this doesn't prevent a thoroughly Christian college from giving their faculty greater freedom to speak out or be controversial in the classroom or take a position in a published paper that is an unorthodox position. Yeah. But if it leads to the dismissal or other sanction of that faculty member, they would be unprotected in a employment discrimination lawsuit. And just to show you how strong religious liberty this case is, the teacher handbook at these two Catholic schools in California guaranteed that there would be no discrimination on the basis of yada, 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 you know, race, disability, age, and so on. And yet, notwithstanding the handbook saying just the opposite, the Supreme Court says, no, these schools have First Amendment protection.
Right. You know, we won't take any longer with this and go to number 4, but it is somewhat up close because of our relationship with scholar Dr. Sarah Sumner, who's been here on several occasions as a friend of TEI's, dismissed by Simpson University through kind of, you know, kind of flippantly without respect for a contract. So this is up close, and I'd be curious to ask you to kind of look at those cases and the work that she's doing. So I do know that for faculty, it's like a disgruntled president or provost can be quite dismissive of an individual just for them trying to exercise leadership, et cetera. Yeah. So that's why I'm curious about it.
These internecine struggles go on all the time. If the group here is kept up on what's happening at the MU campus, the provost, backed by the interim chancellor, just dismissed, effective immediately, the dean of the College of Education. There's pushback by the faculty, and so on and so on and so on and so on. So these kinds of struggles go on all the time, and but but I agree with you. I agree with your observation that this shifts the balance of power in favor of the religious institution maintaining its religious character
Right.
as it determines, and not having the government in the form of lawsuits interfere with those religious decisions.
Yeah, and there's a lot to celebrate in that as well.
Yeah.
If you'll be mindful of the time, let's go to number 4 so we can finish at 1:15. Okay.
All right. Well, Little Sisters of the Poor is this case, this lawsuit, and this litigation. This is the contraception mandate that came out of Obamacare. This litigation has been going on for 9 years, and unfortunately, it's going to keep going on. But there's a momentary victory here for religious liberty. So it's a victory, but the dispute's not over. So you recall there was litigation all over the country. I think there were like 250 different religious organizations that sued the federal government because of the Affordable Care Act, euphemistically Obamacare, because regulations promulgated under the Affordable Care Act said that the health insurance policy that you had to supply, the minimal coverage, had to supply 33 different kinds of contraception. And of course, any kind of contraception, artificial contraception, is contrary to Catholic doctrine. So this mandate came up against all Catholic institutions. And if you were biblical, two of these drugs and one of the IUDs acted as an abortifacient. So it destroyed the product of conception. So for evangelical Protestants and conservative Protestants, those 3 kinds of contraception, having to supply them, went against your religious faith. This is the same dispute that led to the Hobby Lobby case, 5-4 case, decided in 2015, I guess. And a number of for-profit religious groups, including Wheaton College, which we just mentioned, College of the Ozarks here in Missouri, and others, Sharp Holdings, Charlie Sharp, a strong Christian evangelical, sued the federal government and so on, because they wanted a religious exemption from the contraception mandate, and the Obama people were unwilling to give it because they were backed by feminists who wanted that contraception no matter what. So in 2016, we had a change in administration. The new administration came in and said, we're going to give all these religious organizations the exemption they want, and all these lawsuits go away, which of course they did. But they also gave an exemption for a morally based objection to contraception. So it was a religious based exemption and a morally based exemption. And they did the change under the Administrative Procedure Act rather hurriedly. Just 30 days notice and comment period, and then put the new rule into effect. And that promptly mooted out all of the lawsuits because the religious groups got what they were suing for. But then a bunch of feminist groups convinced the states of Pennsylvania, the Attorney General, who was a feminist, and the Attorney General in New Jersey to sue the Trump administration for these regulations. And they made 3 claims. And in this lawsuit, Little Sisters of the Poor, a Catholic order, who was subject to the contraception mandate for their employees, they intervened in these lawsuits. And so New Jersey and Pennsylvania sued And they made three claims. Number one, that the new administration, the Trump administration, did not have the authority under the Affordable Care Act to extend exemptions to all religious groups and all morally based objectors. Because in theory, a morally based objector could even be a for-profit, publicly held corporation. And the second argument was that they didn't follow the regulations of the Affordable Care Act. And then the third argument was that the Trump administration relied upon RFRA, the Religious Freedom Restoration Act, in granting the exemption at least to the religious groups, not the morally based groups. So this, and the courts below ruled in favor of New Jersey and Pennsylvania, and so the case went to the Supreme Court. And again, by 7-2, religious liberty wins. The Trump administration was upheld. But I say 7-2, it was really 5-2-2. The 5 conservatives gave the Trump administration a win without reservation. They said the Affordable Care Act did allow the new administration to make these regulations exempting religious groups and morally based groups, and that they did follow appropriately the regulations of the Administrative Procedure Act. And third, that it was prudent for the Trump administration to take into account the Religious Freedom Restoration Act, at least as to the religious exemption. 2 liberals, Kagan and Breyer, concurred, said that yes, Little Sisters should win, but we're only ruling on the first 2 grounds, that the Affordable Care Act did grant the authority and the Administrative Procedure Act was followed. They said nothing about the Religious Freedom Restoration Act. And then we had 2 dissenters, Ginsburg and Sotomayor. So it's a victory for the Religious Freedom Restoration Act. However, now the case goes back down for further proceedings under the Administrative Procedure Act. And so New Jersey and Pennsylvania can continue to complain that features of the Administrative Procedure Act, not an issue on this appeal, can be raised and will be litigated. The problem is, if we have a change of administration come January, the new administration will wipe out the religious exemptions, which the Trump administration gave us, and probably reinstate no exemptions as we had under the Obama years, which will mean that all these religious organizations who are newly subject to now a new contraception mandate will sue again. Which a cynic might say is a way for law schools to employ their new graduates. Rod, back to you.
What was the motivation of the 2 liberals who did not give RFRA credence?
Well,
do we know?
We don't know because they were silent, but one would have to assume they did not agree with the majority, the 5 conservatives. They did not agree that RFRA required a religious exemption, but we don't know. I don't want to put that into Kagan's head and Breyer's head. Maybe they just say, we don't need to rule on that today. Kagan did say the moral-based exemption is really dubious because you can't use RFRA for a moral basis. You can only use RFRA for religion. And of course, the First Amendment, free exercise clause, only protects religion. It doesn't protect general, morally held, strongly held moral views. So she may have a point there, and she called that protecting morally based, especially for-profit, publicly traded corporations. She called that overreach, and it does look like overreach.
Gotcha. As we wrap up, is there something coming down the pike at a state level or at a federal level that you're keeping your eye on?
Oh, absolutely. Next October, the Fulton case. The Fulton case, another case brought by Catholics, Catholic opposition to same-sex marriage. City of Philadelphia funded private organizations to find foster homes, including Catholic Charities. But when they found out that Catholic Charities refused to place foster children with same-sex marriage homes, because that was contrary to Catholic doctrine, they jerked the money. That was the string. They said, oh, you're discriminating against gays and lesbians. And so Catholic Charities sued, and it's in front of the Supreme Court. And 3 of the justices said, we want to hear this case because we want to reconsider the Smith case of 1990 with an eye to overruling it. And I'm hoping, I've filed a brief with the court asking them to overrule the Smith case. The Smith case gutted the free exercise clause. And so I want the Smith case reversed.
Okay, very good. Well, as always, you served us really well. So applause from all of those who are still with us. What I'm going to do is, do you have a few minutes to hang around, Carl?
Oh yeah, absolutely. Yeah,
Okay,
I was going to say, I'm sorry, I rattled on too long, and
you didn't. I'm glad that we got to hear from you, because that was the primary thing that we want to do. But I will, even though we're dismissed, I'll leave this open for a while until y'all get done. And then Prof, when you have to go, you can sign off as well. But indeed, let me unmute everyone. And then those who have to go, goodbye. And those who'd like to stick around, especially the attorneys that may be still there, might want to have some further conversation. So give me just a minute. Thanks again. Y'all can also just unmute yourself. So feel free to do that while I search for getting all this done here.